and gentlemen, Elder Quentin L. Cook.
Good morning, ladies and gentlemen, colleagues and friends. It is my great honor to introduce our first presenter, Professor, former 10th Circuit Judge Michael W. McConnell. Professor McConnell is the Richard and Frances Mallory Professor and Faculty Director of the Constitutional Law Center at Stanford Law School, as well as a Senior Fellow at the Hoover Institution at Stanford. He graduated from the University of Chicago Law School in 1979, served as a law clerk for the United States Supreme Court Justice William Brennan, and later became assistant to the Solicitor General of the Department of Justice in the Reagan administration. There and later in his illustrious legal career, Professor McConnell has argued many cases before the Supreme Court. From 2002 to 2009, Professor McConnell served as a circuit judge on the United States Court of Appeals for the 10th Circuit. He was nominated by President George W. Bush, a Republican, and confirmed by a Democratic Senate by unanimous consent, something rarely seen since. We are blessed that Professor McConnell's great work and calling is to be one of the nation's foremost scholars of constitutional law, with a particular focus on understanding and protecting religious freedom. From this post, he has had a massive influence on religious liberty law. There is at least a little irony in the fact that Professor McConnell clerked for Justice Brennan. Drawing from Jefferson's metaphor, Justice Brennan's jurisprudence often reflected the vision that church and state must be strictly divided by a high and impermeable wall of separation. By the time Professor McConnell began his legal career, that conceptual framework had become a constitutional excuse for walling out religion from critical institutions and sometimes public discourse, as if religion were some kind of dangerous contagion best kept in the private closet or sanctuary of personal devotion. The First Amendment's religious clauses were then understood to conflict with each other rather than working together to preserve a vibrant and holistic religious liberty. Professor McConnell knew better. A man of deep Christian faith, he understood that religion in America, in all its rich diversity and splendor, is an indispensable foundation of the identities, families, and communities of tens of millions of Americans and a critical pillar of American democracy. So he got to work debunking false historical narratives and tenuous legal doctrines rooted more in elite social preferences and ideology than in the text, history, tradition, and logic of the Constitution. His scholarship and public service has deepened our national commitment to a far richer understanding of the place of religion and thus the role of religious freedom, not only as an individual right, but as a cornerstone of a pluralistic and democratic society. Through his writings, teaching, mentoring, and judicial opinions, Professor McConnell has advanced a vision of religious liberty that is both principled and inclusive, one that respects a religion and religious institutions and safeguards the right of all faiths and traditions. That vision, backed by impeccable scholarship, has inspired advocates and shaped Supreme Court doctrine for decades. As John Garvey, former president of Catholic University of America, has said, Professor McConnell is the most important figure in the way American law thinks about religious freedom in the last 50 years. We are so grateful, Professor McConnell, for all you have done to advance the cause of religious freedom. As a member of the Quorum of the 12 Apostles of the Church of Jesus Christ of Latter-day Saints, I express my personal gratitude and that of our church for your great service in that notable cause. You have been a friend to all faiths, my own faith included. Please join me in welcoming Professor Michael McConnell as he now addresses us on the topic of religious liberty, where we've been, where we are, and where we're going. Professor McConnell.
Thank you for that warm introduction, and thank all these people in this room. This is a very impressive gathering this morning. I wish that I could be with you all day. Alas, I have to dart away to teach my class at NYU in just a few moments after I speak. I'd like to give a safety warning. You need to put on your seat belts. Because in about 20 minutes, you might get whiplash, or I'm not sure what the right metaphor is. There is no field of constitutional law in which the United States Supreme Court has done such a complete and entire U-turn than in the area of religious freedom. It is, and over a period of about 40 years. That's about how long it took for this, and it's still happening. But right now, I think what we're seeing is they're kind of picking up the pieces and cleaning up the messes and trying to figure out how to move forward. But the major steps have happened. So, what do I mean by that? So, as most of you presumably know, the First Amendment of the United States Constitution contains a clause about religion, usually referred to as clauses. We don't even know whether there's one or two. And it says, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. One might think this is actually a single clause. It only uses the word religion once, and it has two different things about it. And I believe that the two provisions were originally understood, and as a matter of philosophical civil libertarian theory ought to be understood as working together. What they do together is to disarm not religion but the government. First, just the federal government, and now state and local government as well, taking away from the government its power to be able to control religion, either by giving benefits to it, special privileges to it, like what Jefferson and Madison objected to, which was a proposal to force everyone to pay a tax to the church of their choice, but still force everyone to contribute to religion. That's a benefit to religion. Or from penalizing religion, making religion harder, burdening religion. And those two things should not be at odds with each other. But the Supreme Court rather euphemistically referred to this as the tension in the clauses, but in truth, the way they interpreted the two clauses made them in just core opposition to one another. So let me just give you a couple of examples, and I'm going to try to choose examples from what is to me the beginning, which is the beginning of my involvement with this, which would have been, roughly the end of the 1970s, beginning of the 1980s, and then I'll refer to more recent decisions later. But so the court held that the free exercise clause was violated when a Seventh-day Adventist person could not get unemployment compensation because she refused to sign something saying she would be available for work, and by that they meant all 7 days, meaning including her Sabbath. And she said, I can't agree to be available for work on Saturday, and therefore she did not get unemployment compensation. Supreme Court held that that violated the Free Exercise Clause. By the way, that decision was written by my boss, William Brennan, who's referred to in the introduction. He was a separationist on the Establishment Clause, but a pretty strong defender of the free exercises. He was one of these people who did think they meant opposite things. But then at the same time, the Supreme Court was saying that if a government decided to give support, a subsidy to all private education, for example, by providing bus rides or textbooks or tuition vouchers or tuition tax credits, some sort of subsidy for all private religious education to encourage the possibility of private alternatives for parents, that it violated the Establishment Clause to include religiously affiliated schools in that. Now think about those two decisions that are at the same time, same period of time in Supreme Court history. Well, if it was unconstitutional to deny the Seventh-day Adventist a benefit because of her religion, why was it not equally a violation of the Free Exercise Clause to deny a religious school a benefit to which they were otherwise entitled because of their being religious? Seems as though the court's own Establishment Clause violated the Supreme Court's own Free Exercise Clause. But it works the other way around too. If it is a violation of the Establishment Clause to include a religious school and enable a religious school to receive generally available public benefits without renouncing their religious faith, if that violates the Establishment Clause, why didn't it violate the Establishment Clause to insist that a Seventh-day Adventist be able to receive unemployment compensation even though she wasn't available for work on Saturday? I mean, everybody else had to be available for work on Saturday. Isn't that some kind of a special benefit? And when you really drill in even to the words of the Constitution, to give protection to the free exercise of religion, note that it doesn't give a protection to the free exercise of other things, other important things in life, lots of other important things too, but the Free Exercise Clause singles out religion for a particular kind of a legal protection, right? And if the Establishment Clause, now we don't really, it's hard to know what the word establishment means without knowing a lot about the history here, but what the Supreme Court said it meant, I think wrongly, but they said that it meant was a government policy that advances religion. And sometimes they would say give special protection for religion. Well, protecting the legal right is a form of, it advances. Is it not true that if you have a legal right to engage in something that advances it? I mean, if somebody said, I have a protected legal right to ride the subway, I would think you'd say, well, okay, well, that advances subway use, right? And so if you interpret the two clauses this way, it's not that there was some, on the margins, some mild possibility of clash, not some, quote, tension, the way the Supreme Court put it. It meant that the two things were just, and they interpret the two clauses, and maybe even two parts of a single clause, in opposite ways. Well, this made absolutely no sense, and it did not advance any of the plausible reasons why we might protect religious liberty in America. Well, these things have been, the doctrines on both sides of this problem have been unwound and turned around. It's most conspicuous for the Establishment Clause, and I am most happy with the way the Supreme Court has moved with respect to the Establishment Clause. It took them 40 years, but at least they got there, and it went in a couple of steps. First, there were a few cases where individuals were caught up in this Establishment Clause problem. So there was a case called Witters versus Department of Services for the Blind, in which the state of Washington had a program where anyone who was legally blind, they would pay for them to get post-secondary education leading to a job. It was a vocational program, right? But Larry Witters' chosen profession was he wanted to be a minister. And so they said, oh, no, it would violate the Establishment Clause to give state money for somebody to go to school and learn how to be a minister, right? That would violate the Establishment. Supreme Court unanimously held, no, that isn't right. That's because he's not getting this benefit because he's religious. He's getting it because he's blind. Sort of the government is being neutral as to the religion. And I think that case and a few others were like the germ of an idea that ultimately sprouted into a full-bore doctrine that the Establishment Clause doesn't require separation in the old sense. It is a kind, even neutrality is a kind of separation, right? So I don't dislike the word separation, but neutrality is really a better word. So first they held it doesn't violate the Establishment Clause to treat religious institutions neutrally, to treat religious speech neutrally. I've done a lot of free speech cases, and students, when I tell them this, are shocked. But when I first got into this line of work, religious clubs like Bible clubs or whatever were forbidden in school. That is, you could form every club you wanted, including in universities. The Supreme Court had said that the SDS could not be excluded. You have to include everyone, because the Free Speech Clause says, a free speech for everyone, but not religion. That was the exception. So that is completely reversed. So first the court says that the Establishment Clause allows governments to treat religious organizations neutrally. And then, in the second step, it's actually moved to saying, in fact, it's unconstitutional not to treat them neutrally. That is, that if a religious organization like a student Bible club or like a religious school or like a missionary society or you name it, there are any number of religious entities, if they qualify under the terms of the program, they cannot be excluded because they are religious. This is exactly the opposite. What the court was saying had to be done back in 1970, now they're saying is unconstitutional to do the same thing, that is, discriminate. The developments on the free exercise side are more complicated, and I don't have a lot of time. I'm not sure I can do justice to this, but just a few observations about this. So there were not very many free exercise cases in the courts or in the Supreme Court, and they were a little bit at sea, but on the surface, the doctrine looked pretty good. It said if there was a burden on the exercise of religion, then that was unconstitutional unless the government had a really good reason, like what the courts call a compelling governmental interest to punish it. But again, there weren't a whole lot of cases. Most of the controversies are not actually about punishing people because of their faith. It's usually about exclusion from benefits. But, there are a couple punishment cases, like the very first written free exercise case is under the New York Constitution in the 18 teens, and it involved requiring a Roman Catholic priest to testify to secrets that he had learned in the confessional. He was subpoenaed to appear in a criminal case. And he said, no, I can't do that. And they were going to throw him in jail, and the New York court, in the very first written opinion about free exercise, said it would violate the free exercise clause of the New York Constitution to throw him in jail for that. More recently, the Supreme Court decided a case about whether the use of hallucinogenic substance, that is peyote, which is used in the sacramental practices of the Native American Church, and we know that this is true because anthropological evidence tells us this has been true. This has been their practice for 500 years, or back to the mists of time. But question is, can they be punished under the drug laws for their sacrament? Had there not been an exemption in the Volstead Act during Prohibition, Catholic and Protestant churches and Jewish services that use wine as part of their religious practice would all have been violating the criminal law of the United States. Well, the first question is, does denial of a benefit amount to a burden? And there was a kind of old-fashioned view that was adhered to by especially conservative members of the court that said, no, nobody's constitutionally entitled to a benefit. It's true, you can't be punished for your religion, but you don't have any constitutional rights to benefits, right? And the problem with that view is, what is a benefit? Is it anything that the government does from which we benefit? Well, how about unemployment compensation? We pay unemployment compensation taxes. It's not supposed to be a kind of social insurance, right? But if you have a religious view that makes it impossible to swear that you will be available for work on Saturday, you pay the taxes, but you don't get the benefit. Well, how about the benefit of a statute, subsidizing private education? The first step, in other words, was for the court to make clear that denials of benefits are burdens on religion. Now, the second thing is really more complicated, and I think the gong is about to sound from the very idea of whether free exercise is special became contested. Because at the beginning of this period that I'm talking about, the court said, burdens on religion, unconstitutional unless there's a compelling governmental interest. But some of the justices said, no, that's too strong. It's really not a burden on religion unless religion is being singled out. So if we have a law against all drugs, all illegal drugs, all it's controlled substances, it's not a violation of free exercise to send a member of the Native American Church to jail for using peyote in a sacramental service, because they're just being treated like if anyone else used peyote, they'd be thrown in jail too. That was the reasoning of the court. If we had time, I'd love to tell you why I think that that's wrong, both as a historical and theoretical matter. But the short run is this case, which is called the Smith case. It's still on the chopping block in the Supreme Court. Said free exercise clause does not protect against neutral and generally applicable laws. Well, what happened after that? It looked like a disaster for free exercise, because almost every free exercise case involves exactly that. And the first step was that Congress stepped in, and they passed a statute saying, well, that may be what the Supreme Court thinks, but we say in the Religious Freedom Restoration Act that any burden on the practice of religion can't be is illegal, violates federal law unless it can be justified by a compelling governmental interest. Supreme Court then says, well, that's unconstitutional as applied to state and local laws. So Congress then passes a couple of other statutes in very specific areas where it has more power, prisons, for example. Prisons and land use planning are the most important examples. Meanwhile, states all around the country, I think it's 37 at last count, pass something very similar to that under state law. They became controversial suddenly when people dawned on them, well, that actually means even civil rights. That even means laws having to do with same-sex marriage, and maybe that might mean that a florist can't be forced to do flowers for a same-sex marriage. And then that was when these laws became controversial. But prior to that, it was not really so. But those laws continue to be passed, continue to be enforced. Meanwhile, the final shoe to drop on the free exercise side, warned you this was complicated, is that the court began to realize that what is a neutral and generally applicable law is an extremely complicated question. What makes it neutral? Neutral against what? What's the numerator? What's the denominator? And as the court had more and more cases and thought more deeply about this problem, they began to see that it began to hold in a more religion-friendly way. It isn't neutral if if something that is being done for a religious reason is forbidden, and any secular justification for the same thing is permitted. A very early case involved the Newark Police Department, which had an anti-beard rule for its police officers. Well, there's a medical condition for some men that makes shaving irritate their skin, so they were exempted. But what about Muslim officers? At least some sects of Islam require adult men to wear a beard. Are they exempted? Well, Newark said no. But the Third Circuit Court of Appeals, in an opinion by future Justice Sam Alito, then a judge on the Third Circuit, said, well, actually, yes, because if Newark lets men with medical conditions wear beards, but not men with religious conditions, they're favoring one kind of justification above and disfavoring religion relative to that. Well, that line of thinking has now taken over, and Supreme Court now finds free exercise protection in a much broader range of cases, even when the law doesn't, on its face, discriminate against religion, but where in practical operation it does exclude religious people from general benefits of public life. That is now unconstitutional. So I think you can, the seatbelt sign is off. I don't see anybody calling for a lawyer to sue for whiplash, so I consider my job done. Thank you.